I said earlier in the week that I would do a podcast regarding the abolition of the not proven verdict. For people watching from outside Scotland, or people who are unfamiliar with the Scottish criminal trial system, there was an unusual feature, still is, but it's about to change, of Scottish trial procedure where there were three verdicts available to the jury. So in England, for example, the jury would be told that if the case wasn't proved beyond reasonable doubt in the jury's mind, then they should return a verdict of not guilty. Whereas in Scotland, they would be told that if they were not satisfied beyond reasonable doubt, then the accused should be acquitted, and could be acquitted either by a verdict of not guilty or by a verdict of not proven. Seems a bit confusing until you explain it, and anytime I've explained it to people, they're easily able to understand the concept. But historically, actually, the third verdict, the newspapers always refer to the not proven verdict as the third verdict. But to be historically accurate, actually in Scotland, the not guilty verdict was the third verdict, because in the 1700s, we had moved to a system where the jury were given a number of factual propositions. For example, did X stab Y? And they had simply to answer proven or not proven in relation to each. And then the lawyers interpreted those answers into a verdict of sorts. But there was a case involving a gentleman known as Carnegie of Finhaven. There isn't an awful lot of detail about the case, but what seems to have happened is that he ran somebody through with his sword because he had verbally been, the other party had verbally insulted him. And the jury were given the proposition whether he had run the guy through with a sword. For some reason, this particular jury were extraordinarily sympathetic to the swordsman, and obviously realised if they said that it had been proven, then he would be executed. So they insisted, this rebellious jury insisted on delivering a verdict of not guilty, which really meant for the first time there was a third verdict. And from about the mid-1700s, Scottish juries have had the option of the three verdicts. Now, I could very easily be persuaded that given that the question the jury is asked to answer is really a binary question, I mean, either the case has been proved beyond reasonable doubt or it hasn't, so there's only really two ways of answering it, and it seems logical to me that there should only be two verdicts. So I can understand why the politicians had to look at it. Personally, I would prefer if the Scottish Law Commission had looked at it, but I'll come back to that. But logically, the verdicts open to the jury should be proven and not proven, and that could have been recorded by the court as guilty or not guilty. And every lawyer I've explained this to, it wasn't my idea, I heard it from other people, but every time I explain this notion to lawyers, they can easily understand it, and I think if we had moved on to a two-verdict system of proven and not proven, it would put us ahead of every other legal system in the world. But that wasn't really the intention. The intention was not to put Scotland ahead of every other legal system in the world, or even to make trials fairer. It was pretty obvious from an early stage that the purpose of the law reform was to try to obtain more convictions in sexual offence cases, because, you know, any time this subject is debated, the justification for reform is always we don't get enough convictions in sexual offence cases. The Justice Minister has denied that, but it's quite difficult to take the denial seriously when the bill also included a proposal to suspend jury trials in sexual offence cases, which got quite a far distance through the committee stage, actually, despite the fact that almost every lawyer in the country was dead against it. And judges, retired judges, were against it. But it got quite far, and really the only reason they eventually pulled it was that some of their own, it's quite a narrow majority they've got now. Well, they don't, the SNP don't have a absolute majority, but usually the Greens vote with them. It seems to have come from the fact that they pulled the juryless trials proposal was really more to do with numbers. The fact that they didn't think they would get the numbers to push it through. They never conceded it was a really, really bad idea, which it undoubtedly was. Especially when they more or less declared at the beginning of the debate that the concern was a lack of conviction. So imagine the position that would have put a temporary judge in, where he or she is given a rape trial without a jury, and the government has already said that the purpose of the exercise is to get more convictions, So anyway, they pulled it. I suppose we should be grateful for that. But they went ahead and abolished the not proven verdict, which is described rather dramatically in a article as an act of self-mutilation, but that's what I regard it to be, and on the subject of sexual offence trials, they are often very, very close calls in these cases, because quite a lot of them, the case really comes down to one person's word against another. So they hear the woman who's making the complaint, usually is a woman by quite a large majority. So to take the classic case, the woman gives evidence, she's absolutely believable and credible. The man gives evidence, he's also absolutely believable and credible. And remember, in most of these cases, the issue is seldom whether or not there was sexual intercourse between them. The issue is usually there's an agreement, there was some form of sexual contact, and the issue is whether it was consensual or non-consensual. And that's quite a hard thing to decide, because there's very unlikely to be any independent evidence one way or the other. Perhaps the women seem to be distressed after it, but there can be more than one explanation for that, clearly, and sometimes the accused has an explanation as to why she might have been upset. So in those cases, when the jury have heard the two main combatants and they believe them both, then not proven is the ideal verdict in that situation. The jury is not saying that the woman is a liar. They're not saying even that they don't believe the woman. They're saying that they believe both of them, which is possible to do. And not guilty would be going too far, because the jury might think, well, if we return a verdict of not guilty, it looks as if we believe the man and we don't believe the woman. So, to communicate the fact either that we do believe both of them, or I suppose in some cases we don't believe either of them. When the onus is on the Crown to prove the case beyond reasonable doubt, the not proven verdict's absolutely perfect. But we're going to abolish it. And my concern is, in those finely balanced cases of the type I've just illustrated, the jury might think it would be going too far to deliver a verdict of not guilty. And if they don't have the not proven verdict, which they won't have when this completes its parliamentary progress and gets royal assent, then my worry is that people who should be acquitted because the case hasn't been proved beyond reasonable doubt will be convicted. I think that's the aim of the legislation, to be honest, and it's really, really deeply concerning, because in Scotland the government are undoubtedly influenced by influential pressure groups. I mean, I've spoken about this issue before. I've been on television debating with one influential pressure group, and it's quite staggering to think that Rape Crisis Scotland only launched its campaign to abolish the not proven verdict in 2019. And 6 years later, they've done it. You know, it's been talked about for years and years. I think it was misunderstood by many when you explained to them exactly what it was and what it meant. Then people were easily able to understand it. And the other disturbing aspect of it is that the government knew that there might be resistance to it, and if they simply said we want to increase conviction rates, then some people would be offended by that. So they said things like, there is evidence that juries don't understand the not proven verdict. Now, nobody in Scotland has ever spoken to a juror to see what they understand and what they don't understand. In England, Professor Cheryl Thomas has been doing research for years, and there's no compulsion in the juries to comply with the research, or I think they're simply given a number and told if they want to talk about their experience they can phone, and Cheryl Thomas has got a team that's put together really, really useful research. We've never done it in Scotland. We had a pretend jury pilot. It was very, very well constructed. I'm not taking anything away from the academics who did it, but they weren't jurors. They didn't speak to any jurors. They spoke to people who were pretending to be jurors, and the Scottish Government then jumped on it and started talking about it as if they had been jurors. I mean, it's like we were talking about reform of the way in which lawyers cross-examine witnesses, and you go and speak to Joe Pesci on the basis they once pretended to be a lawyer in a movie. I mean, it's ridiculous that you go and speak to people who were playing at being jurors. You know, everybody on that fake jury, knew that nobody had been assaulted, nobody had been raped. It was just a pretend video. So when they came in to deliver the verdict, they knew that there wasn't going to be a complainer sitting in the court in tears because there was no conviction. There wasn't going to be a 17-year-old in the dock in tears because his life had been ruined by a conviction. These are the stresses that jurors have to experience, and none of these pretendy jurors experience that. And, you know, the Justice Minister and Rape Crisis talk about this pilot as if it was actual jurors that they were spoken to. So absolutely no evidence whatsoever that juries don't understand the not proven verdict. They do understand it because I speak to them about it, the prosecutors speak to them, the judges speak to them, and every now and again you see it. And when you see a not proven verdict, it's usually easy to understand why they delivered it, you know, that because some really important witness has been caught out committing perjury or has admitted that he gave 3 different statements and he doesn't really know which, if any of them, was the correct version. So you can see it, you know, they don't just bring them out of nothing. Usually there's a pretty obvious basis for it. So it's a sad day. It was a sad day for Scotland last week when they decided to do this, and of course it's never going to come back. So whenever this makes its way through Parliament and receives royal assent, then we'll be down to 2 verdicts. And in England, the jury are sent out initially to deliver a unanimous verdict of 12 jurors in England, and I understand that after a couple of hours the judge will indicate he or she can accept a 10-2 verdict. We're not doing that either. You know, at the moment in Scotland, incredible as it sounds, you can be convicted of murder and sent to prison for life with a minimum of 25 years on an 8-7 vote. You know, it's a simple majority. And the new legislation is moving to a 2/3, so we have 15 jurors. So the Crown will need to get 10 jurors for a conviction, but that's still a lower percentage than in most common law countries which accept 10-2. So, you know, we're losing the so-called protection of a third verdict. I was never particularly convinced it was a protection. Really, there was two verdicts. It was acquittal and conviction. The acquittal verdict could be expressed in two ways, which was only ever really described as a difference of emphasis. And I think some people thought, well, if we believe the accused, or the case is so bad that it should never have been brought, then it should be not guilty, and in every other example it should be not proven. So to be honest, in most cases the verdicts which were realistic were guilty and not proven. So in most cases really there were only two realistic verdicts. Anyway, that's 15 minutes, so I've spoken enough. As ever, if anybody has any questions about the not proven verdict, or anything else for that matter, please just put them in the comments and I'll come back on, and if there's enough I'll come back on and answer them. If there's one or two, I'll just probably answer them in the comments. Anyway, thanks very much for listening. Bye.